The next case on the call of the docket is case agenda number 7, 126931, In re ZL et al. Minors and versus the state of Illinois versus KG. I know that Counsel Cass Payne and Ms. Gupta, you'll be sharing the time, and keep yourself aware of the time. All right, thank you. And as well as you, are you going to be sharing the time? I don't have that listed. No. No. Okay, thank you. Go ahead.
May it please the court, counsel. I'm Assistant Public Guardian Cass Payne, and I represent the children in this case, ZL, who I will refer to as Z, and her 3 older siblings. I will focus my argument on Arthur H. and various sections of the Juvenile Court Act, and also address the findings of neglect, environment, injurious to Z's 3 older siblings. Ms. Gupta from the Attorney General's office will focus her argument on the post-petition evidence used to reverse the adjudication findings, Arthur H., and the constitutionality of the neglect, environment, injurious statute. I can also answer questions on any issue. This court should not overturn its precedent in Arthur H. because the holding correctly interprets the plain language of the Juvenile Court Act, which is, in order to find a child abused or neglected, the trial court does not need to find that both parents caused the abuse or neglect or identify which parent caused the abuse or neglect. This holding is supported by numerous sections of the Juvenile Court Act. First, Section 2-18(1) states that the court shall first consider only whether a child is abused or neglected. Section 1-31 says that the purpose of an adjudicatory hearing is to determine whether the abuse or neglect allegations are supported by the preponderance of the evidence. But most importantly for this case, Section 2-21, subsection 1 of the Juvenile Court Act instructs that if a court determines that a child is abused and neglected, then the court shall specify, to the extent possible, the acts or omissions that form the basis of the court's findings. As Arthur H. held, there may be times when a child is neglected, but the trial court cannot determine the relative fault of the parents. Arthur H. is holding that the court must determine a child is neglected and not whether a parent is neglectful furthers the purpose and policy of the Juvenile Court Act, which is to protect children. Requiring parents to be found neglectful would lead to the unacceptable position that a child is either abused or neglected, but by only one of her parents, then that child would be without the protection of the Juvenile Court Act.
Counsel, is there any tension between the holding of Arthur H. and the holding of AP?
No, those are 2 different situations. In re AP did not involve parents. In re AP involved a mother's boyfriend. And it's a very different case because, especially from this case. But in re AP, the boyfriend was caring for AP when he suffered a scald injury. And AP actually cites to Arthur H. saying that children are neglected, parents are not neglectful. And there was no apportioning of culpability between either parent because when AP was injured, he was not with either the mother or the father. Also, especially for this case, where we have married parents who were both co-parenting all 4 of the children. Not only would a child be without the protection of the Juvenile Court Act if both parents have to be named perpetrators of the abuse or neglect, but if the court can't determine who caused the injuries, then that child would also be without the protections of the Act. But that is exactly what the appellate court here did when it said that Z was not physically abused or neglected because Miss G herself did not shake Z. The trial court in this particular case did not name a perpetrator of the physical abuse because it could not determine whether the mother or the father injured Z, 3 months old Z, and who caused her abusive head trauma, which included subdural and subarachnoid hemorrhages and damage to her corpus callosum, which are the nerves between either side of the brain.
Ms. Plain, was there any time put on when ZL injury occurred?
No, because it's an abusive head trauma, both Dr. Jones and Dr. Lebioda testified that it's very difficult to age the blood in the brain. So it happened within a few days before the images, the MRI and the CT scan. That was the reason why the trial court could not determine whether it was the mother or the father who were the perpetrator of the physical abuse. But here the appellate court found that because Mr. L, the father, may have injured Z, Ms. G did not abuse or neglect Z. But Section 2-32I of the Juvenile Court Act defines an abused child as a child whose parents inflicts or allows to be inflicted physical injury by other than accidental means. That section does not require the trial court to name both parents the perpetrators of the physical abuse or determine which parent caused the physical abuse. This court should not overrule its 16-year precedent in Arthur H. and its correct interpretation of the Juvenile Court Act. In addition, the appellate court misapplied the law when it reversed the neglect due to an injurious environment findings for ZL's 3 older siblings, NL, SL, and EL Jr. First, the appellate court found that Z's older siblings did not suffer any harm, but as Arthur H. holds, citing In re Brooks, the juvenile court does not have to wait till each individual child suffers an injury before taking action. Also here, the appellate court found that Ms. Z did not negligently endanger her children by leaving them with her husband and did not willfully leave them in an injurious environment. But as Arthur H. says clearly, neglect encompasses both willful and unintentional disregard of a parent's duty. And also, once again, Section 2-21 of the Juvenile Court says that the trial court does not need to determine that both Ms. G and Mr. L neglected the children. There are numerous appellate court decisions that hold that when one child is physically abused, the other children living in the home with the victim of physical abuse and parented by the same parents is neglected due to an injurious environment.
Ms. Pink, may I just ask a quick question? One of the arguments here is that this trial court relied too heavily on the death of the eldest child where abuse was indicated in terms of the ultimate decision of what to do with the other children. Was that inappropriate evidence to rely upon?
Well, it was in the petitions for adjudication of wardship. It was one of the allegations. But in the trial court's ruling, the trial court does not mention the death of TL at all. It is just one of many factors, the most important of which is these 3 older siblings were living with ZL when she suffered her abusive head trauma. It is just one of the many things that contributed to the injurious environment. Also, Section 2-18 3 of the Juvenile Court Act states that the abuse or neglect of one child shall be admissible evidence as to the abuse or neglect of any other child that the parent is responsible for. The evidence at trial at the time that Z suffered her abusive head trauma was that the 3 older siblings lived with Z, her mother, and her father, who were co-parenting and responsible for all 4 of these children. There's other allegations in the petition, as Justice Tice referenced. One of them is Mr. L admitted that after Z stopped breathing, he did not seek medical attention for her. And also, both parents had prior indicated reports for death by abuse, for the death of 5-week-old TL that the parents were responsible for, and TL's death was considered a homicide. It was ruled a homicide by the medical examiner. Arthur H. holds that neglect due to an injurious environment includes a parent's breach of their duty to ensure a safe and nurturing shelter. NL, SL, and EL Jr. were not in a safe and nurturing home in August of 2018 when Z suffered her abusive head trauma. If your honors have no further questions, on behalf of the children, the public guardian requests the court reverse the appellate court's decision, affirm the trial court's finding that Z was physically abused and neglected, that the 3 older siblings were neglected due to an injurious environment, remand the case back to the trial court for a determination of proof of compliance with the notice requirements of the Indian Child Welfare Act, and for a new dispositional hearing. Thank you.
Ms. Gupta?
May it please the court, Assistant Attorney General Priyanka Gupta for the people. In the Juvenile Court Act, the General Assembly put forth a step-by-step process for determining whether minors should be made wards of the court. This case concerns the adjudicatory phase of that process, during which, as this court has held, the court is to determine whether minors have been abused or neglected. The appellate court here misunderstood this inquiry, and thus its decision overturning the adjudicatory findings should be reversed. I'll be focusing on 3 of the issues raised in this case. First, the appellate court's analysis of parental culpability. Second, its reliance on irrelevant evidence. And third, the mother's constitutional challenge raised for the first time in this court. To start, as my co-counsel has argued, the only question to be resolved at the adjudicatory phase is whether a minor has been abused or neglected, not which parent is to blame. I will not belabor this point, but would simply like to add that the appellate court here made the same error that the appellate court made in Arthur H. There, the appellate court determined that a minor was not neglected because his father was not neglectful. And here, the appellate court determined that 4 minors were not abused or neglected because their mother was not neglectful or abusive. But as this court correctly explained in Arthur H., this analysis is legally erroneous and leaves children without the protections of the Act when only one parent is found to be the perpetrator. The appellate court's decision should also be reversed for an independent reason, and that is that the appellate court improperly relied on evidence that the minor's father had moved to Ohio during the course of the proceedings. Section 1-3 of the Act provides that an adjudicatory hearing is a hearing on whether the allegations of a petition are supported by a preponderance of the evidence. As the appellate court has repeatedly held in cases such as S.W. and Kenneth D., this means that only evidence that bears on the allegations is relevant. All other evidence about parental conduct, such as, for example, a parent engaging in services after the incident, is instead properly considered at the dispositional hearing. That is what occurred before the juvenile court. The juvenile court heard testimony at the dispositional hearing that the minor's father had moved to Ohio, but he was still visiting his children at least monthly and wanted to regain custody of the children. And the juvenile court then determined whether the father was fit and able to have custody of his children. The appellate court, however, at first recognized in paragraph 36 of its decision that the relevant evidence was evidence that concerned the conditions of the children prior to state intervention. But it then ignored this limitation and focused instead on evidence that the father had moved out of the house during the course of the proceedings. This was error because it shifted the focus from whether the children were abused and neglected in August 2018, as alleged in the petitions, to instead where the father was living currently. To be clear, we are not advocating for a bright line rule that any post-petition evidence is irrelevant. This is not a case such as Adrika C., where the post-petition evidence revealed that the child did not suffer from the blood disorder that was alleged in the petition. Instead, our point is that any post-petition evidence that does not bear on the allegations is not properly considered when overturning adjudicatory findings, and thus the appellate court's decision should be reversed for this independent reason. Finally, I'd like to address the mother's argument that the statute defining neglect due to injurious environment is unconstitutionally vague. The mother chose not to raise this argument before the juvenile court or the appellate court, and thus forfeited this argument by raising it for the first time before this court. Accordingly, this court should not reach that claim. But even if it does, it should reject this argument because the mother has not carried her burden to show that the statute is unconstitutional. As this court has repeatedly explained, statutes carry a strong presumption of constitutionality, and due process only requires a statute to provide reasonable notice of the prohibited conduct. It does not require absolute precision or require more specificity than is required under those circumstances. And here, the circumstances are a neglect inquiry. As this court has explained in cases such as Arthur H., neglect must have a fluid meaning because such inquiries are fact-driven. This accounts for the myriad of contexts in which children might face harm at the hands of their parents. Applying these principles, the mother has not shown that the neglect due to injurious environment statute is unconstitutional. The statute here prohibits an injurious environment in which a child is neglected, and this court has explained that that includes the breach of a parental duty to provide a safe and nurturing shelter. The statute provided the mother with reasonable notice that the facts alleged here constituted a neglectfully injurious environment. And the facts, again, were that an infant suffered abusive head trauma while in the care of her parents, and that her 3 siblings were cared for by the same parents and lived in the same household. So the statute, and especially given its construction by this court, provided the mother with notice that such conduct would constitute neglect. Accordingly, even if this court reaches this claim, it should reject it. If there are no questions from the court.
Respondent mother relies on in re MI to circumvent forfeiture. How do you respond to that?
Yes, Your Honor. In re MI requires a juvenile delinquency prosecution, and in those cases, the standards of criminal proceedings are applied, whereas in abuse and neglect proceedings, civil standards apply. And this court has held that in this criminal context, a claim that a statute is unconstitutional can be raised at any time, but it has not held that in the civil context. And in fact, quite the opposite. In cases such as Garza, which was cited in our brief, this court has noted that a challenge to a civil statute that is raised before the court is forfeited. And there is good reason for this distinction. Otherwise, parties could raise challenges to civil statutes at the 11th hour before this court, despite having every opportunity to raise them before. And this court should not reward such inaction. Here, the mother was represented by the same counsel that represents her now at every stage of the proceeding. But that counsel chose not to raise this argument, and thus this court should not consider it at this late stage. And in re MI does not change that analysis because it involves criminal standards. But again, if this court reaches that argument, it should reject it. If there are no other questions from this court, for the reasons stated just now and in our brief, we ask this court to reverse the appellate court's decision that overturned the adjudicatory findings of abuse and neglect. Thank you.
Thank you, Ms. Gupta. Mr. Lemons?
Good morning, and may it please the court. My name is Jeremy Lemons, Assistant Public Defender, and I represent the respondent appellee, KG. Briefly, I would make one point before proceeding to the reasons why we think the appellate court was correct in this matter. And that is, the record before the trial court and the record before the appellate court and this court contained over 6,500 pages of medical records. And those records, as well as the 4 days of evidentiary testimony that the trial court heard, contain only evidence that KG was loving toward all of her minors, specifically ZL, that KG, well, specifically CL, that KG repeatedly and constantly called and went to the hospital when ZL was initially hospitalized in the NICU for the first 4 to 6 weeks of her life, and that when she was hospitalized again, that KG was very loving, emotionally attached, and bonded, as was ZL. In that context, the appellate court properly recognized that the state's interest in protecting vulnerable minors, though compelling, the state registers no gain toward that interest where a minor or any group of minors has a fit, willing, and able parent. And the appellate court was correct on that reasoning for 4 reasons.
If we agree with your position, counsel, do we have to overrule Arthur H.?
No. Arthur H., as we argue in our brief, is consistent with AP for a couple of reasons. First, Arthur H. and AP both put great weight on the fact that there was a fit, willing, and able parent. This court noted in Arthur H. that the parent, in that case a custodial father, was there to care for the minor, notwithstanding the fact that the mother, who, pursuant to the findings of the juvenile court, left Arthur H.'s siblings home alone, left the home that Arthur H.'s siblings lived in disarray, and failed to properly follow up with Arthur H.'s siblings' medical issues. The court presented with that evidence and the evidence that the mother in the case had some legal right to still see Arthur H., though there was no evidence that she would or that she would pick him up. But in that context, this court noted that there was no evidence, and this goes to the state's burden, that there was no evidence that the mother would obtain Arthur H., and so the injurious environment that extended to Arthur H.'s siblings simply could not extend while Arthur H. was in the care of his father. And in that context, Arthur H., we think, makes clear that where you have a fit, willing, and able parent, the state's interest simply does not come into play. And this court reaffirmed that principle in AP. And I note the distinction, or the lack of distinction, between this case and AP. It is correct that this court's decision in AP dealt with a neglect case. But it's important to note that the decision also dealt with a paramour who, pursuant to 2-3 subsection 2, is part of the class of individuals who may be someone who abuses a minor, just like a partner or spouse. And so in that context, the court was presented with non-rebutted medical testimony or evidence that that partner abused AP. Notwithstanding that, the court below and this court and the appellate court declined to find or reverse, due to a lack of a finding, that there was no physical abuse finding made. But the fact of the matter is that in that case, as well as the findings of this case, there was a blameless mother who left the minor with a caregiver that she had no reason to know would place the minor at risk. And this court made very, very clear that that cannot extend to neglect with respect to the mother, because the mother, as well as any parent, reasonably, in the course of caregiving, will leave the minors with individuals that they find suitable.
Could you help me understand exactly what part of the order that you're attacking? The court found initially that the child was abused. There was a debate of experts, and the court agreed that the child was abused while in the custody of both parents. Are you challenging that finding?
We are. We, in argument 1 of our brief, argued that that finding was against the manifest weight. However, we also think...
Between the experts?
Yes. And we lay out, as well as the amicus that was filed on our behalf by the Center for Forensic Integrity, lay out why we think that the state, even before we get to our expert, Dr. Scheller, and the child's primary care physician, Dr. Akand, why the state simply couldn't meet its burden where Dr. Jones was, well, her testimony was not supported by the state's own evidence, which was the Loyola medical records, was contested by the Loyola neurology or neurosurgery department, and where Dr. Lebioda, his opinion was contested by the very consensus statement that he relied.
But the appellate court didn't engage on that, correct? The appellate court didn't find that it was inappropriate to rely on one expert versus the other expert, correct?
That's correct.
So you're not, well, the appellate court didn't reach that. So are we focusing on the abuse finding, or are you more concerned about the findings of neglect as to the other children? Which part of the order are you asking us to focus on?
We certainly put great weight in our argument that the siblings should not have been neglected. Contrary to the arguments of opposing counsel, this court made very clear in Arthur H. that there is not and there cannot be a per se rule that the abuse or neglect of one sibling or minor constitutes conclusive proof of abuse or neglect of that minor's siblings. Likewise, in this case, and we make this argument in argument 2 of our brief, there was no, as Arthur H. requires, probable or substantial risk to ZL's siblings where they were, first, very differently situated. When the petition was filed, E.L. Jr. at that time was about 13. His other siblings were 8 and 4, respectively. To the extent that the appellate court, or that the juvenile court, and this is the issue with the finding with respect to ZL, because the juvenile court, with no additional evidence, found neglect toward the siblings. And that finding, it simply cannot stand in light of this court's decision in Arthur H. And so, at the very least, with respect to the siblings, and I would note that the appellate court looked to the dispositional evidence, and we think that's appropriate, to find that the state certainly had no interest where the minors regressed in the care of the state. E.L. Jr., the dispositional evidence was quite clear, started to act up in school, he started to have behavioral issues, and at some point, he made clear that he was upset that his case was DCFS involved.
But again, now you're getting to what happened between the adjudication and the dispositional hearing. And that's one of the issues here as to whether or not that's actually even relevant.
That's correct. We think, and we point this out in argument 4, that the appellate court correctly recognized that the juvenile court, consistent with section 1-2 of the Juvenile Court Act, which states the purpose, has an obligation and a duty to constantly reevaluate whether or not removal from the parents is necessary. This court reaffirmed that principle in In Re JJ. Though factually distinct, In Re JJ dealt with the case where the state filed a motion to dismiss, the guardian objected, and the juvenile court indicated it had no authority.
Wait, you're talking about removal now. Removal and adjudication are 2 different things. You're attacking the adjudication order, correct?
Yes.
Okay. So the removal order became final at the dispositional hearing. I mean, there were interim orders of removal after that. I'm just saying, let's focus on this adjudication order.
Okay.
In answer to Justice Garmon's question, you said that we don't have to overrule Arthur H., but then you start going into apportioning fault between the 2 parents, that your client was not at fault, whereas the other parent was at fault. How is that not apportioning blame between the parents in contradiction to what was said in Arthur H.?
It's not because there was no evidence of blame with respect to KG. Our argument is not that this court must look to specific cases and say one parent was, this level of culpable and that parent was that level. Our argument is that the state has to prove that each parent breached some duty before proceeding to a custodial determination, which the adjudication finding, as we note in our brief, is merely one part of. As Your Honor points out, it is a distinct part of the adjudication or the petition for adjudication of wardship. But as we argue in argument 4 of our brief, that finding is, as this court noted in Arthur H., a preliminary finding. And as the appellate court noted, it's interlocutory in the sense that it's not final. It is just a preliminary finding that the state has to prove before it can get to this question of custody. And so what we argue, and this is supported by AP, and we note in AP that under the state's rule and under the guardian's rule, in that case, the state waited about 2 months to file its petition, contrary to this case where they only waited about a week. In that context, the mother in AP was able to show what she needed to show to establish that she was a fit, willing, and able parent, including separation from the paramour. In this context, the state argues, pursuant to how quickly they filed the petition, that evidence isn't relevant because it happened after the petition was filed. And this goes to part of our argument in argument 1, that simply can't be the standard. That arbitrary period or time where the state determines to file its petition cannot be the standard or the line as to whether or not a minor is abused or neglected, especially when the state does not give the parent an opportunity to correct the conditions. And this goes to argument 4 in our brief, all comes back to the purpose of the adjudication and dispositional hearing.
But the state does give a parent an opportunity to correct conditions. I mean, that's part of what the dispositional hearing is about. You have permanency hearings. But it's not arbitrary, is it? I mean, this is the allegations are this child was abused or neglected, or these children were at a certain point in time. What happened since then, that is more appropriate at the dispositional hearing. That's the framework, is it not?
So, yes, the Juvenile Court Act creates a framework where the first determination on the state's petition for adjudication of wardship is whether or not the minors were abused, neglected, or dependent. In that context, and we think that this goes more to procedural safeguards than necessarily limitations on the arguments of the parents. But in that context, the state has to first prove that the minors were abused, neglected, or dependent. But as we noted in our brief, and as the appellate court noted, that is in the context of the state coming to the juvenile court and saying, we need to take custody. If the state does not come to the juvenile court with a need to take custody, then there is no reason, and this is what the appellate court found, there is no reason for the adjudication hearing, there's no reason for a dispositional hearing, there's no reason for a petition for adjudication of wardship. And I note that the guardian concedes or acknowledges in our brief that effectively what the juvenile court found was that there was a change in circumstance. And we point out in our brief that the legislature specifically designed a remedy where a family or where there is a material change in the family's circumstance such that the minors can be cared for without risk. And that is under section 2-10, subsection 9, subsection B. And that section, not subsection B, but subsection 9, allows the juvenile court, upon a motion of any party, to vacate or modify the temporary custody order, including the finding of probable cause. And so this goes back to the question that the juvenile court, that we think this court admonished the juvenile court with respect to in JJ, where this court said that the overriding purpose of the Juvenile Court Act is to ensure the best interests of the minor, the family, and the community, and that both the state and the court have a continuing obligation to ensure that purpose is served. The appellate court noted the additional purpose of the act, which I noted previously, which is to, as much as possible, preserve the relationship of the family, separating them only when necessary, returning them as soon as possible, and intruding to the least amount as necessary to protect the interests of the minor. And so in that context, and this is what we note in argument 4, in that context, as the appellate court properly noted, there simply can't be an interest of the state to protect a child, and such that the state comes into court seeking to divest a parent of custody where they don't establish that that parent is not unfit, unwilling, or unable. And we note that in this case, the lack of a finding about any breach of duty, any act or omission with respect to KG, or any parent, but specifically with respect to AKG, rendered the dispositional hearing confusing, to say the least. Because what the state and the guardian proceeded to argue was, well, KG needs to address the fact that the babies were abused, that the baby was abused, and that she possibly was the person who abused the babies. And when you're talking about correcting the conditions, which is admittedly the purpose of the dispositional hearing, we have to take a step back and ask, what conditions are we correcting? And that is the burden of the juvenile court to articulate to the parents, and this is also noted in section 2-21, right under the section that talks about acts or omissions, that should the court make findings, the court must then admonish the parents that they should correct the conditions or risk termination.
May I ask a question again about the original order? Did the court find that the child was neglected because the parents did not bring her to the appropriate medical treatment?
So yes, the judge did make findings of neglect due to lack of necessary care.
And is that also, wasn't there testimony as to the mother and her, what she did or didn't do when the child stopped breathing?
So the juvenile court, as far as I recall, didn't make a factual finding with respect to why Zia was neglected due to necessary care. Your Honor is correct that the evidence in the record and the arguments of the state were that she shouldn't have left the emergency room so quickly. But as the appellate court noted, the primary care doctor, as well as every other medical professional, had no problems with what KG did. And we noted that the next day, when she promptly followed up with the primary care doctor, Dr. Akan noted that the baby seemed healthy and that there was no issue. And she only advised KG to go to the emergency room when the baby vomited at the doctor's appointment. And I think this is critical because it goes to our argument that the findings for Zia were against the manifest weight. The only reason she did that was because she thought the baby was dehydrated, which then gets into the evidence of that being a risk factor for a stroke, which was one of Zia's neurological conditions. But back to and I think that Your Honor is correct, Justice Tice, with respect to the focus of our argument. The appellate court properly recognized, and we think that this is consistent with the long-standing principle outlined in Stanley versus Illinois, that the state certainly has an interest in ensuring that minors are protected, but that it serves no interest where there is a fit, willing, able parent. And in this case, as I noted when I started, throughout the thousands of pages of medical records, throughout the testimony that took place over 4 days, the court had nothing before it to indicate that KG in any way breached her duty of care to any minor, or that she acted in any way or failed to act in any way that placed any minor at risk of harm. And so for that reason, as well as the other reasons that we outlined in our brief, and as well as the arguments of amicus, we ask this court to affirm the holding of the appellate court and vacate the findings of the juvenile court for all minors, but especially for the siblings. Thank you.
Thank you, Mr. Lemons. Ms. Plain?
This court will have to overrule Arthur H. This parental fault doctrine that KG is espousing, it will definitely not only have to reverse the holding in Arthur H., but also rewrite the plain language of the Juvenile Court Act. You do not have to apportion, no, both parents don't have to be found to be abused or neglected. And going into the facts of Arthur H., the holding in Arthur H. was because Arthur lived in Milwaukee with his father and was not subject to the injurious environment in the mother's home. That's why he was not found to be neglected. It has nothing to do with a fit, willing, and able parent. Regarding In re JJ. In re JJ is a case where the state moved to dismiss its petition for adjudication of wardship because it felt that it didn't have sufficient evidence. After that happened, the trial court was instructed to allow a hearing to determine whether or not it was in the best interest of the minor to dismiss the petition. That is not relevant to this particular case. And going into the medical neglect of Z, the petition alleged that when Z stopped breathing, Mr. L did not call 911. Dr. Jones testified that when parents have a premature baby, just like Z, and Z was at the NICU in Loyola, they are instructed to call 911 when a baby stops breathing. And there was also a conversation. Ms. G goes home after the father calls her and says, Z stops breathing, and she says, should we call 911? And he says, no, you always overreact. We took CPR, this is what preemies do. But Dr. Jones stated that, parents are told to call 911. Also, Dr. Akand instructed the mother to take Z to the emergency room. And she did. She waited 2 hours. The Adventist Bolingbrook medical records show that the chief complaint of Z was an abrasion to the right cheek. There is nothing in there about, my baby stopped breathing, my husband had to perform CPR, and the pediatrician instructed me to come. So, there was medical neglect in this case, not just physical abuse, neglect, environment, injurious. And as to these 3 siblings, they were neglected. Arthur H. instructs that you don't only use the theory of anticipatory neglect to prevent physical abuse to a child, but also neglect to a child. Now, this is the second time E.L. Jr. is involved in DCFS care. There were also other allegations regarding the environment injurious of this home, including that another child died, a 5-week-old child died while in the care of the parents. So we would ask you not to overrule the 16-year precedent in Arthur H., and not to ask to rewrite Section 2-18, Section 1-3, Section 2-211 of the Juvenile Court Act, which states that at adjudication, the issue is the child abused and neglected? Then, after the finding of abuse or neglect, to the extent possible, the court determines the acts or omissions of each parent. In this particular case, that could not be done. There was not enough evidence to show whether the mother or the father was responsible for Z's injuries. And therefore, the finding of physical abuse was appropriate. As I stated, the parental fault doctrine will require Arthur H. to be overturned and a rewrite of the Juvenile Court Act. If your honors have no further questions.
Ms. Gupta?
Thank you, Your Honor. I'd just like to make 4 points. The first is that, as my co-counsel noted, Arthur H. was correctly decided, and our colleague asked this court to overrule that decision, but the legislature has amended the Juvenile Court Act, particularly Section 1-3, upon which this court relied on in Arthur H., 12 times since that decision, and it has never rewritten the act in the way my colleague advocates for. The second is that, as this court noted in its questioning, there is no custodial determination at the adjudicatory phase. That is simply a hearing on whether the children have been abused or neglected. That's what occurred here. The juvenile court entered those findings. It did not make any determinations of custody. Instead, that determination happens at the dispositional hearing. And there, the parent's interest, where a parent might be fit and be able to take care of their minors, is protected. Under Section 2-27 of the Act, a minor that has been adjudicated a ward of the court cannot be placed with a third party unless their parents are found unfit or unable. So this parental interest in taking care of their children, while very important, is protected for and accounted for at the dispositional hearing. The third is that the temporary custody hearing is not at issue in this case. My colleague referenced Section 2-10 of the Act as a reason for why the appellate court properly revisited the adjudicatory order by looking at irrelevant evidence. But as he recognized, 2-10 concerns the temporary custody hearing, which happens before the adjudicatory phase. However, the mother never filed a petition for leave to appeal from the temporary custody hearing, and thus that decision was not assessed by the appellate court and should not be assessed by this court. And fourth, Stanley against Illinois is an opposite to this case. In that case, the United States Supreme Court said that the Illinois statutory scheme, which presumed that unwed fathers were unfit and therefore their children could be taken away from them at the dispositional hearing, that statutory scheme was unconstitutional. That is not the statutory scheme we have before us today. Rather, as I have explained, during the dispositional hearing, the juvenile court must assess parental fitness before it can place minors with a third party. And so therefore, the animating concern in Stanley against Illinois is not present in this case. And so for these reasons, as well as those raised in our brief, we ask this court to affirm the adjudicatory findings of abuse and neglect and reverse the appellate court's decision on this point. Thank you.
Thank you, Ms. Gupta. Case number 126931, In re ZL versus KG, will be taken under advisement as agenda number 7. Thank you, Ms. Plain, Ms. Gupta, and Mr. Lemons for your arguments this morning.